Engineers for the last several months, and there's always this question about how wetland delineations are handled and building permits, when you have wetlands on them, that type of thing. And so as we talked, we thought it might be good to have him come down and do a presentation. It's good to see Heber and Midway here, and we thought it'd be good for staff and commissioners and council members to hear that. So if it's okay, I'll just turn it over to Mr. Bohannon and he'll go through his presentation. All right, thanks, Doug.
Good afternoon, everyone. Thank you for having me here today. My name is Samuel Bohannon. I'm one of the regulatory project managers for the U.S. Army Corps of Engineers. I'm joined by Mr. Hollis Jenks, who is another regulatory project manager, the Army Corps of Engineers. We're located out of the Bountiful Regulatory Field Office in Bountiful, Utah. If anyone for any reason needs to come out and visit us, we're located right next to Parsons Bakery, so it feels noteworthy.
Yeah, you have a card you can leave at maybe the office or something.
Yeah, absolutely. So I'm going to jump right into it. So the Corps' regulatory program, we are a federal agency and we have jurisdiction through a few federal laws that allow for reasonable economic development while also protecting our country's aquatic resources. It's important to note that we are neither proponents nor opponents of projects. If things are submitted to our office, we follow process, we follow our guidance, and that is how permits are issued. So we have permitting authority from 2 federal laws, Section 10 of the Rivers and Harbors Act of 1899. That one's not very relevant for Wasatch County, so I'm not really going to go into that one, but the meat and potatoes of our regulatory program is Section 404 of the Clean Water Act of 1972. And I just want to instill that law, the portion of that law, Section 404, regulates the discharge of fill material or dredge material being excavated riverbed or lake bed.
We're just directing traffic.
Yeah, no worries. So the discharge of fill material, i.e. earth or dredge material, lake bed, riverbed, into waters of the United States, including wetlands. Waters of the United States, we have a diagram here that shows a whole bunch of different examples of them. We've got navigable waters and their tributaries, interstate waters and their tributaries, adjacent wetlands to those waters. So in layman's terms, rivers, lakes, streams, wetlands, we have jurisdiction over those if you are going to be putting a discharge of fill or dredge material into them. So when I talk about jurisdiction is more or less what we have authority over through Section 404 of the Clean Water Act. So as Doug had mentioned, there's kind of this cloudiness over wetlands, and wetlands have a 3-parameter approach: wetland vegetation, hydric soils, and hydrology. If those 3 criteria are met, it's considered a wetland, and it may have jurisdiction under the Clean Water Act. Additionally, I'll also be mentioning the ordinary high water mark. When we talk about lakes or rivers, where there's the fluctuation of it, there are these physical traits that you can see, and anything below the ordinary high water mark is what our office has jurisdiction over. So once again, a discharge of dredged or fill material in wetlands or below the ordinary high water mark, we have jurisdiction over, and those things require a permit. So this is a diagram kind of showing how that looks. Ignore the tidal waters because that's relating more or less to things that are not relevant for Utah or for Wasatch County, but fresh water on the right side of that diagram. So what sort of activities would require a permit? If we were to think of residential development, Wasatch County has a lot of development going on. That's no surprise to anyone here. And a lot of the upland areas, the things that are outside of waters of the United States, are typically already built on already because they're easy to build on. So now we're left with a lot of areas that may have waters in them, like wetlands or rivers. And so when we have residential developments, commercial developments, recreational developments, those things require permits. Bank stabilization, linear transportation crossings, any of these things may be regulated under our office. And if there are any concerns, it's always a great thing to just call our office before putting shovels on the ground. So our permitting program, we have multiple permits. The most common ones that we have, one of the first two common ones are the PGP-10. That's our programmatic general permit, otherwise known as the PGP-10. The turnaround time for this permit is about 20 days. This is in conjunction with the state of Utah's Division of Water Rights Stream Alteration Program. So this only has jurisdiction over streams. So bank stabilization projects, if there are road crossings that are near, or a bridge or a pipeline, if there's anything that's going to be next to a stream or in a stream below the ordinary high water mark, we'd have jurisdiction over that. This does not allow for any sort of wetland impacts. And so if there are any wetland impacts, or if the project at hand does not meet the terms and conditions of this, the next most common permit that we have is our nationwide permit, which is typically processed between 45 and 60 days. They allow up to 1/2 of an acre of wetland impacts, or greater than 300 linear feet of stream impacts. And there are 52 different types of nationwide permits that we have, and they're very specific, are activity specific. So bank stabilization, road crossings, utility lines, residential developments, these are things where they would fit into a nationwide permit. Once we get beyond that 1/2 acre of impact for larger projects, then we have permits that take a little bit longer. They require a little bit more coordination with federal agencies, state agencies, such as a standard or an individual permit. I'm going to have Hollis Jenks come up and talk about these larger permits, as he has more experience than I do.
I'm Hollis Jenks. I'm going to talk briefly about the standard or individual permits. So with standard or individual permits, you have to exceed a 1/2 acre of impact to wetlands or 300 linear feet of stream. That's stream loss. That's not above 300 linear feet of impact like bank stabilization. It'd be more like putting a stream in a culvert. With an IP, you would submit an IP, an application to our office, and then we have 15 days to review it. And then once we review it, it goes out to public notice. The public notice goes out to anyone that's interested in our program, adjacent landowners. And it also goes out to like the EPA, all the federal agencies. So EPA, Fish and Wildlife Service, DWR, CITLA, those kind of areas. Also with an IP, you have to comply with what's called Section 404B1 guidelines. And these guidelines are basically an alternative analysis. So you have to demonstrate to us why you have to build your project. And that means that you have to demonstrate to us, for instance, why you have to do a 3-story building instead of a 4-story building to reduce your impacts. Also with it, you have to do 404 water quality cert through the state, and that typically takes about 60 days. Other federal acts that you have to comply with are Section 106, which is basically just cultural resources, and Section 7 of the Endangered Species Act. Now, when we're doing this permit and we're evaluating it, these are all the interest review factors we have to take into account. And so basically what we're doing is we're doing a mini environmental impact statement to come up with if your project's permittable or not permittable. Sacramento District does have what's called a letter of permission. And this is if you're exceeding the threshold of the nationwide permit, which is a 1/2 acre, and you're impacting less than an acre of impact, or an acre of wetland. And this is a 60-day processing time. And associated with this is that every 3rd Tuesday of the month, you would have, if you wanted to come in and get this type of permit, you would have to come into our office, have a pre-application meeting with all the agencies that are interested in your project. And what that does is that they get to look at your project, address any of the issues that they have concerns with, and then you can address them up front. From there, you submit an application to our office, and then we have 15 days to review it, and then it goes out to agency notification. It doesn't go out to public notification, just agencies, and agencies have 15 days to review the permit and see if they have any issues with it. You have mandatory mitigation. So any project that comes into our office, and if it's impacting wetlands and it's impacting more than 1/10 of an acre of wetland, you have to do what's called wetland mitigation. That's a creation, enhancement, or preservation of wetlands. With an LOP, you are guaranteed that you have to do a 2-to-1 ratio. So if you're impacting an acre of wetland, you have to create 2 acres of wetland. Now I'll turn it back to Samuel for the rest of the presentation.
So jurisdictional determinations, not all wetlands are regulated from our office. There are certain wetlands that are isolated. I don't know if any of you have been keeping up with some of the changes to some of the federal laws like the Clean Water Act, where there's going to be a new water rule that's going to be enacted soon. This changes our jurisdiction. So if you have a wetland delineation, say that you're applying for a nationwide permit and you're going to have wetland impacts, or a letter of permission and you're going to have wetland impacts, or an individual permit and you're going to have wetland impacts, you have to hire a wetland consultant, somebody who's qualified. That person is going to assess the property at hand and figure out what sort of aquatic resources are on your property. That's going to be submitted to our office. If you want, there are 2 different ways of going through this. You can either get a preliminary jurisdiction or an aquatic resource verification, which is in short saying, this is my property, I've got wetlands here and here, these are their boundaries, Army Corps of Engineers, do you concur with those boundaries? And we would say yes, and you are foregoing your jurisdiction on that. It's not final say, but for the sake of your permit, you are claiming that we have jurisdiction over those. If you wanted to say, I have this property and I have wetlands here and here are their boundaries, are these jurisdictional? That would be going through the process of the approved jurisdictional determination. It takes a lot longer time for us to verify these. We have to go through coordination with the EPA and certain other federal agencies. And it's a decisive document, it can be appealed, but once we've issued that, that is what we are saying is jurisdictional or not. So if you want to get a permit, if you know that you're going to have something that's going to need a permit, call us. Get us involved early. But this is when you know that you are going to have any sort of impacts to waters of the United States, get us involved. I like to have phone calls saying, hey, I've got a project that's coming up. It might have wetland impacts. What do you think? That is more, it's much better for our office and for the applicant than having somebody make a judgment call that may not be correct, and then we have to go through an unauthorized activity process, which is not desirable for anyone. Avoid impacts as much as possible. Part of our guidance and our regulations say that if you know that there's going to be a project where there are going to be impacts, you have to avoid impacts to the most practical extent. Then you have to minimize those impacts as much as possible. And if you go over 1/10 of an acre, you have to compensate for the functional loss of those, as Hollis mentioned with mitigation. And mitigation is an expensive process. It is a lengthy process, and they need to be maintained in perpetuity. So it's a very long process, even once it's been built. Unauthorized activities. This was something that I've been working for the Corps since April of last year, and in Wasatch County, I have all of my unauthorized activities, and I have 4 of them. It's a lengthy process. Most of these activities are things that our office would have permitted if people had come in and gone through the process correctly. But since they hadn't, it is expensive for them. And the main reason why I'm here today is because I just want to build some awareness of our program, because we have a lot of involvement, especially in Wasatch County, where there's a lot of development going on. There are a lot of waters, big projects. The Corps is involved with a lot of these, and it's just better to be involved sooner than it is later. So if you want to be informed, I'm going to have my contact information at the end of the presentation. Feel free to take a picture of that, call me. I'm the regulatory project manager for Wasatch County. We have regulatory events where we have outreach programs, we have public notice email lists, and of course, when in doubt, give us a call. So this is a map that shows which project managers we have in our office and which counties they reside over. I'm Wasatch County and to the east and a little bit to the south. Hollis Jenks is in green, so he's the southern part of the state. So I'm going to turn this around to anyone who's here and field some questions.
All right, thank you very much. Council, do we have any questions? Is there anyone from the public who'd like to ask a question? Yes, sir, go ahead.
Do impacts to man-made ditches and canals, does that trigger the Corps as well?
I didn't hear the question.
Hey, Bart, would you come up, please?
I can just talk louder. Do impacts to man-made ditches, like irrigation ditches and canals, does that trigger any Corps permitting?
It could, so
Go up to the
it, so in some cases, we do have jurisdiction over ditches. It's how those ditches were constructed, and if that particular ditch, say that ditch is a real-line stream, or that ditch is draining a wetland. So if there's a wetland, feeds a ditch, and then connects with a downstream waterway, we could have jurisdiction over that particular ditch, so it might trigger a permit. Now, typically with ditches, you're looking at, under the nationwide permits, there's some activities that are previously authorized, so you don't have to get a permit from us. You just have to meet some general conditions. And some ditches, it's up to 1/10 of an acre of impact. And if you're impacting below that, you don't need to contact us or get or submit an application with that office.
All right, thanks. Go ahead, Zach.
A lot of times we've got FEMA floodplains, and I'm wondering if there happens to be a lot of situations where maybe they're doing a letter of map revision based on fill or something like that. It could disturb a stream bank or a high water mark. In that case, we'd have to get both FEMA and Army Corps involved.
So if you're impacting streams, you definitely need at least a Utah State Stream Alteration Permit. So the state has jurisdiction up to twice the blankful width of a stream, up to 30 feet. So typically the state, if it's a named stream on a USGS map, or if it has a definitive bed and bank, then they have jurisdiction over streams, and you would get a permit from them. And Samuel was talking about the PGP-10 permit. That's a joint permit we have with them to kind of streamline the process for applicants to make it easier. And if you're going through them, we see all those permits, and if we feel that meets those conditions, we send them an email, say, yeah, it's good to go, and then you can go forward with your project.
I just wanted to know, what are the criteria that the EPA looks at, or these other agencies that review the permits? What's the additional criteria, please?
So the EPA oversees the Clean Water Act. And basically what they're looking at, or NEPA, so the National Environmental Policy Act, and they're looking at to see those 404B1 guidelines, and they're looking at to see that you're minimizing your impacts, basically.
And then you mentioned other agencies that also review your permits.
So Fish and Wildlife Service, they're looking for endangered species and seeing if you're complying with that. State Historic Preservation Office, they're looking at what's called Section 106, complying with cultural resources.
I have to ask one more question, because
Okay.
I did talk with a staff member out of Utah State Wildlife Biology, and she tells me there's a certain frog that's in the North Fields that they would like.
Boreal toad.
Yes, yes. And
I've never dealt with it that much, so you'd have to discuss it with the Fish and Wildlife Service.
Okay.
And I don't know who the expert is, but I can tell Samuel if you want to give him a call, and we'll find out who the expert is.
And then how can we get help on potential new development for parks that would include wetlands
As far as, sorry.
within our city?
The Corps of Engineers doesn't do funding like that, but
No funding, but just information on how to protect the natural environment as well as maybe to enlarge it,
you
but
might,
then to protect it in.
that's
with the park.
potential mitigation for, say, someone's doing a development, so say they're doing a development out in the North Fields, kind of like the intersection out here, and they need mitigation. That could be potential mitigation where that developer does mitigation and you incorporate a park into that mitigation. So you're creating wetlands, but maybe put a boardwalk and some like signs in that teach people about wetlands.
Right, but that would still be permitted through you,
Mhm.
right?
but the mitigation is part of the development.
Right, right, okay.
In the 3 years I've been on the council, there have been several occasions where we have looked at a piece of property, something in the valley, and had a discussion about, similar to something like this, well, this used to be wetlands, but it's not now. Or on this 1965 map, it's shown as wetlands, but that's out of date and incorrect. And so I wonder, I guess my general question is, how is it determined for a legislative body like us what the wetlands are?
Okay, so wetlands are case-by-case scenario. You can use what's called the National Wetland Inventory. That's a Fish and Wildlife has this website, and it's called the National Wetland Inventory. And it gives you kind of a planning approach and shows you basically where wetlands are. It can be very inaccurate, but it can give you an idea. And then once you get to that point, you can hire a wetland consultant to come out, look at the property, and what they're looking for is wetland vegetation. They're looking obviously for hydrology indicators, and then looking for certain soil characteristics that make hydric soils.
So, yeah, kind of along those same lines, if we have a delineation on a property, how long is that wetland study good for once the Army Corps has approved it? We've had a number in Midway that we have a wetland study, 10 years later we have a new study done, there's no more wetlands on site.
And you're going to find that to be kind of the case in Heber because Heber was flood irrigated. Mm-hmm. So obviously there's a lot of natural wetlands in the area, but there's also a lot of flood irrigated induced wetlands. So in those cases, if you get a wetland delineation done, you can come back to us anytime and get another one done if things have changed on that property. So if you got one done in, say, 2016, you find out that, this year that it's changed a lot, you can come and get another delineation done.
Okay, so there's not a specific 5-10-year expiration?
So our jurisdiction, so when we're saying these are under the Corps' jurisdiction, and that we have authority over them definitively, those last 5 years. But within that 5-year period, you can always come back to us. But it's good for 5 years.
Okay.
Permits, tell us the length of a permit before, if I've applied for it, you've reviewed it, how long do I have to act on it before I have to apply again?
Nationwide permits are good for 4 years, but they're reviewed every 4 years. So they're coming up, if you want a permit this year, wait till next year, or if you get one this year, you're gonna have to build this year. Because in 2020, the nationwide permits, the country reassesses those, and we re-look at them to see if they're still current, and then we do the nationwide permits again, and they'll be up again in 2024. So say you got a permit in 2020 and you've started work on that permit or you're under contract to do the work, you get your extension automatically. So say you got a permit in 2021, it would be good till 2024. LOPs, the letter of permission I was talking about, good for 5 years. IPs are good for 5 years also.
Does the Corps, once a piece of property has been delineated as wetlands, does the Corps have a recommended maintenance of the wetlands? Meaning, can I mow it? If it gets matted down, can I burn it? Do you have any recommended maintenance plan?
We don't have recommended maintenance, but we regulate the discharge of fill material. So if you go out there and mow it, you go out there and burn it, we don't have any authority over that. It's when you start putting fill material within the wetland, that's where our authority comes.
Could I plant a tree in it?
In theory, you're supposed to get a permit from us.
Okay.
How does this correlate? I'm just curious. You do a lot of ranching and farming still up there. How does that correlate with the Clean Water Act and wetland?
There's specific exemptions for farming activities. And those are all case by case. Some farming roads are exempt, some like ditching and that kind of stuff, some of that's exempt. But it's all you have to propose to us what you want to do, and we'll tell you if it's exempt or not.
Okay.
Any other questions? Yes, sir.
How do you define navigable waters, or is that even relevant anymore?
Navigable and fact waters, it's still relevant, but we don't hang our head on it anymore. For this area, you're looking at our waters associated with the Provo River, ultimately Deer Creek. Deer Creek has interstate commerce associated with it, with the boating, the camping, that kind of stuff. That would be your traditional navigable water. And then any waterway associated with Deer Creek is potentially jurisdictional.
I guess I'm still just on these little ditches or streams that maybe don't have water year-round or things like that.
So intermittent streams, ephemeral streams, and perennial streams, if you have basically a bed and bank that feeds into another tributary, then it's potentially jurisdictional.
And that may change with the new, what's called the mitigation rule that was just proposed, which is the change to the Clean Water Act. But that has not yet been enacted, so we don't have guidance on how to regulate that. But that may change soon.
If you have a question,
If you have a question,
Yeah.
call us.
And that should, it's about next month that rule might come out, and more likely it'll get held up in lawsuits.
Corbin?
Yeah, just traps for the unwary. Do you have stories of people who are like, "Oh, that's not a wetland," and then it turns out it was? I mean, what should we be concerned about?
Yeah, question.
Yeah, I mean, if it's a questionable area, anyone familiar, if there's cattails out there, call us, definitely. But I mean, you're looking at wetland vegetation first. That's our cursory review, or if it's the area is saturated, or like I said, if it has wetland vegetation, then give us a call.
Is there any scenario where you would say, we see it as a wetland, but the normal person would not?
A lot of cases.
And what do those look like?
Those areas, so if you have wetland vegetation, you have hydric soils, it only takes 5% of the growing season saturate to the surface to be a wetland. So you're talking in this area, 2 to 4 weeks maybe. But it has to have wetland vegetation and also the hydric soils too component.
Okay.
And the Corps used to do delineations, and we'd come out to your property and delineate the property, but we don't have time to do that anymore, so that's why you have to hire a consultant now.
I see. Okay, cool, thanks.
All right, any other questions? Council, anything? Mike, do you have any questions? Okay. Thank you very much.
Sure. If you wouldn't mind, if I could just make one last closing
Please,
remark. I think one last thing that I just want to hammer home is that we are public servants. We're here to help. If anyone wants to call, it's going to cost no charge to them. Even our permits are, for mom and pop things are $10. Is that how much the individual permit is? It's
The individual permit's $100. It actually costs us more to cash the check than for you guys to do the check.
Right. So we're here for everyone. We're just trying to do our jobs and be equitable both to development and the aquatic resources. Thank you for allowing us to come out here.
Thank you, gentlemen. We really appreciate that. Thanks for setting that up, Doug. If we have any questions, we can call you.